the session of the Public Service Commission to order. Secretary Phillips, are there any changes to the final agenda?
There are no changes to the final agenda.
Thank you. First, I'd like to conduct a roll call of the commissioners. When I call your name, please confirm that you are with us. Commissioner Berman?
Here.
Commissioner Alisi?
Yes, I'm here.
Great, thank you. Commissioner Edwards?
Here.
Commissioner Howard?
Here.
Commissioner Valesky?
Here.
Commissioner Majori?
Here.
Excellent. We have everybody here. Okay, our first item for discussion is item 302, case 21E0130, related to the Exelon Corporation and Exelon Generation Company, LLC. Today we will have a presentation by John Sipos, our Deputy General Counsel, Jeff Hogan, the Director of Accounting, Audits and Finance, Bridget Freimeyer, Utility Supervisor, Ryan Coyne, Assistant Counsel, are available for questions. John, please begin.
Good morning, Chair Christian, Commissioner Berman, Commissioner Alisi, Commissioner Edwards, Commissioner Howard, Commissioner Valesky, and Commissioner Majori. With me today, as noted, are Bridget Freimeyer from the Office of Resilience and Emergency Preparedness, and Ryan Coyne and Jeff Hogan. I believe this is Bridget and Ryan's first presentation to the Commission, so I welcome them to the presentation. Turning to item 302, this is a public service law, Section 70, proceeding concerning a proposed transfer of upstream interests of 4 New York nuclear-powered electric generation facilities. In their joint petition to the Commission, Exelon Corporation and Exelon Generation Company, LLC, asked the Commission to either abstain from exercising any jurisdiction over the proposed transaction or, alternatively, to approve the transfer. The concept underlying the transaction here involves the separation of Exelon's 2 business lines, a traditional rate-regulated utility business and a competitive merchant generation business. The transaction and transfer would separate and spin off Exelon Generation from within Exelon and create a new publicly traded investment-grade company. The new company would focus on owning and operating merchant generation and serving customers in competitive energy markets. Following the proposed transfer, Exelon Generation's primary focus going forward in New York will continue to be providing safe, reliable, baseload carbon-free electricity. With respect to New York, the proposed transaction implicates 4 units. Those units are Guinea, Fitzpatrick, 9 Mile Point 1, and 9 Mile Point 2, which are located in Wayne and Oswego counties with a collective rating of approximately 3,300 megawatts electric. And since 2017, these facilities have participated in the Clean Energy Standards Zero Emission Credit Program. In addition to generation, the New York facilities also have associated decommissioning trusts, which were initially capitalized by ratepayer funds authorized by previous New York State Public Service Commission orders. And these sites also store spent nuclear fuel that has not yet been collected by the federal government. From an operations and reliability and safety perspective, Exelon Generation has confirmed that it will continue to employ the same management and workforce team and follow the same operational protocols. This was important to the OREP team and to DPS staff, and thus from a baseline or status quo perspective, those employees and operational protocols will continue. The Commission has before today both the joint petition and the parties' joint proposal, which augments the petition. staff submits that the joint petition and the joint proposal, taken in concert with one another, advance the public interest. As an initial matter, the new corporate entity will be a publicly traded investment-grade company. This was an important aspect to the Office of Audits, Accounting, and Finance, which evaluated the proposed transfer. The draft order before you determines that Exelon Generation and its subsidiaries, within the context of the new corporate framework, have the financial wherewithal and technical qualifications to continue to operate the New York facilities in a reliable and safe manner. The joint proposal is consistent with New York State public policy and adds several important protections to the public interest. And as part of the joint proposal, Exelon Generation agreed to the following, and I'll just review the salient high points. First, Exelon agreed to the continued maintenance of emergency operation facilities within New York State. This resolves a concept recently raised by Exelon to consolidate all Eastern State emergency operation facilities at a site in Pennsylvania. Second, Exelon Generation has agreed to deposit an additional $15 million into the 9 Mile Point Unit 2 Trust in early 2022 and before the completion of the transaction. This additional deposit will help reduce and diminish the gap in that trust when benchmarked against the federal formula. Third, Exelon Generation has agreed that there will be a maintenance of a initial minimum trust balance of $144 million per unit, or $576 million totaled across the 4 New York units. The joint proposal includes financial assurance provisions that protect the public's interest in ensuring that Exelon Generation and its affiliates do not exhaust the trust funds before they complete the necessary decommissioning and site restoration work at the New York sites. The various minimum balance provisions will ensure that the funds remain well capitalized until certain significant project milestones are achieved. And with respect to site restoration, Exelon Generation has also agreed to establish a parent guarantee to address site restoration costs for each facility and to support that commitment with a third-party surety bond if the company investment grade falls below the investment grade rating. Taken collectively, these financial assurance conditions will help effectuate thorough and prompt site restoration and decommissioning. Fourth, Exelon Generation has agreed to a 20-year projected backstop timeline for decommissioning following the end of licensed terms. This is a real and significant improvement over the NRC deferred 60-year parameter known by the phrase, quote, safe store, SAFSTOR, close quote. And at the same time, from staff's perspective, the joint proposal leaves in place an earlier 2001 commission order, which incents prompt commencement and the continuation and the completion of decommissioning at the 9 Mile site. Fifth, Exelon Generation has acknowledged the New York State Department of Environmental Conservation 10 millirem cleanup guidance standard for residual radiation as part of the New York State site restoration obligation. And this 10 millirem standard is more protective than the federal 25 millirem standard. Sixth, there is an agreement to provide annual and detailed decommissioning trust fund reporting to DPS. And from a timing perspective and a substance perspective as well, this is an improvement over the current 2-year summary level reporting to the federal agency, a schedule that may be extended further to 3 years going forward. So both from a timing and substance perspective, this is an improvement. And Exelon Generation has also agreed to a twice-a-year report to DPS throughout the decommissioning process, once the decommissioning process starts. Finally, the joint proposal provides for an 18-month advance notice of shutdown. This is an improvement over the 12-month NISO provision, and lessens the need for a quick turnaround and should assist state planners. The joint proposal before you, along with the petition, is the result of negotiations amongst parties whose interests have been adverse in other proceedings. At the end of the process, the Alliance for a Green Economy, the Attorney General's Office, the Long Island Power Authority came to support and signed on to the joint proposal, along with the Exelon petitioners and DPS staff. And as we note, or as the draft order notes, initially LIPA indicated that it did not oppose the proposal, but on December 7th, it joined the proposal and submitted its formal assent and signature. Thus, all parties have joined and support the joint proposal. The petition also provides for new financial support agreements for the New York State and Maryland facilities. The support agreements will provide support in the following amounts for the New York sites. For Gannett, $118 million, for Fitzpatrick, $85 million, and for the 2-unit 9 Mile Point site, $128 million. That's a total of approximately $331 million for the New York sites, as well as $126 million for the Calvert Cliffs site, which is in Maryland. I'd like to just touch briefly on the public comments that were received. There were approximately 2,800 or more than 2,800 form type of public comments that expressed concern with Exelon and the proposed spinoff here. Many of those commenters noted that Exelon held over $2 billion in decommissioning funds for the New York reactors, which were, as we noted earlier, ratepayer funded. Those comments suggested that those funds be used, managed and used responsibly. There were also comments in support. Local union IBEW Local 97, that's the union with members supporting the operations at the Fitzpatrick and 9 Mile units. The Building Trades Council, the local governmental entities, including counties, towns, and school districts, filed comments in support. And in its statement in support, Exelon Generation noted that on October 18, 2021, Exelon Generation signed a memorandum of understanding with IBEW Local 97 in furtherance of their ongoing relationships following the closing of the proposed transfer and transaction. That concludes staff's presentation. Again, Bridget Freimeyer, Ryan Coyne, Jeff Hogan of OAAF, and I are available for questions. Thank you very much.
Thank you very much. I think it goes without saying that this is a very significant accomplishment. One, getting all the various parties, as you mentioned, that are often on disparate tables, different side of the tables, together to agree on this, I think, in and of itself shows how significant your efforts have been in achieving goals that are in support of New York's interests and the interests of New Yorkers. I don't think I can thank you enough and congratulate you enough for the job well done. But I really want to make sure you recognize that this is a significant milestone. The simple fact that we're going to be able to decommission these plants in 20 years rather than the recommended 60, that in and of itself is a huge accomplishment. But the financial protections you've accomplished and achieved through these negotiations, I think, are just as significant. So I want to fully support this, and I'll ask my fellow commissioners if they have any other comments. Starting Commissioner Berman.
Thank you so much. And Ryan and Bridget, congratulations on your first time presenting. I'm going to make this short. I'm going to be in support of this. I think this was a really collaborative effort. I was really glad to see that Agree New York signed on. It's the second time in separate matters recently that they have signed on to the joint proposal. So I'm glad that they felt it was inclusive. Kind of looking forward, obviously this issue, a lot of these issues were not as contentious as others for them. So, just a note, kind of working with that process seems to have worked here. I also want to say a special thank you to Commissioner Howard, who I know has been very active in engaged with staff on this issue that we have now before us. So that's it. Thank you.
Thank you. Commissioner Alisi, how do you vote?
Thank you, Mr. Chairman. As it looks, all interested parties seem to be fine with this, and it serves the public interest. The joint proposal addresses critical issues relating to finances and reports, decommissioning and related issues, as well as monitoring by the state and maintaining emergency ops centers within New York State. So I'll be supporting this.
Thank you. Commissioner Edwards?
Yes, I will also. Thank you, Chair. What was accomplished here is just absolutely wonderful. The collaboration, the 7 points, the negotiations to bring all of the parties together. Couldn't be more pleased, and thank you very much for all that you have achieved here. We have a long way to go in order to achieve our goals, but this is a really big step. So thank you very much.
Thank you. Commissioner Howard?
Thank you, Mr. Chairman. First of all, to say this is merely a good job would be an enormous understatement. It is precedent-setting, not only for New York, but I believe for the United States as well. And in my comments later on, we'll elaborate on that. First of all, I believe this company has an extraordinary obligation to the state of New York. First of all, I can give you $7+ billion of ratepayer money that support these 4 units. And without that, by the company's own admission, that subsidy, these plants would have ceased operation some time ago. So again, that is number one in our obligation. Second of all, the parent of this company, it should be pointed out, has had serious corruption allegations in the state of Illinois, and those are being pursued by various law enforcement and prosecutorial entities in that state and with the federal government. So that was the background by which we started this case. But I do have a couple questions I'd like to elaborate on. First of all, on workforce, and I understand that the communication between the bargaining unit and the company sort of outlines a plan for remaining headcount at the status quo going forward to the period of going forward for the next few years anyway?
Yes, Commissioner Howard, it is our understanding that from both a management strategy perspective and also a workforce perspective, that Exelon Generation plans to continue the current approach that they have had at those 4 facilities. They are going to continue the operational protocols and the parameters that they have. So it's our understanding that they are going to continue with their workforce and with their management team that they have at the New York facilities.
Also, in terms of if and when not a question of if, but when these plants move to decommissioning, and with our shorter time frame for that activity, I'm making the broad assumption it gives a greater opportunity for the incumbent workforce to participate in those decommissioning activities, much like we have seen at Indian Point. Is that a safe assessment?
That is a correct observation. One of the advantages of prompt decommissioning is that it provides the opportunity for the workforce that has been recently at that site, operating that site, knows that site, walks that site, comes to that site on a daily basis to participate in decommissioning. And that is an advantage for the decommissioning undertaking, because you have, in that situation, you have knowledgeable people who have been working at that site, who can contribute their knowledge, their institutional knowledge, for the next phase, which is decommissioning. So that is in fact a recommendation, or it's a synergy, if you will. It both helps the decommissioning be effective, it helps the decommissioning be prompt, and it provides the opportunity for continued employment.
Great, thank you. You know, as a former Oswego County resident, I just want to go on record that these 3 units, particularly in Oswego County, are the backbone of that county's economy and a huge chunk of the overall central New York economy. So in addition to the benefits they provide statewide for 3,000 megawatts of zero emission electricity, it does provide an enormous financial kick in the pants for the central New York economy writ large. I think it's safe to say that those people who are fortunate enough to work at these Exelon facilities are maybe the highest paid and best benefited workers in the region. Another couple comments I will make. First of all, the fact that these plants now appear to be and have seemed to be at all-time capacity levels. They are running better than they ever have in their lifetime. I guess the question to Bridget is that, from you've observed these for a long time, including plants like Fitzpatrick, who didn't operate for a long time. So would you say that how would you characterize Exelon's management in terms of the day-to-day operation of these facilities?
Just to start, you're right, they have been performing at a very high level. A few of the plants in recent years have had breaker-to-breaker runs, which mean that they start up after their refueling, and they run either the 2 years or the 18 months up until their next refueling. And I have recognized, and we've spent a lot of time looking at, Exelon's focus on reliability of their equipment and keeping a very active look at some of their aging equipment to make sure that they replace that equipment before it fails and can impact operations.
Great, thank you. Also, could you elaborate a little bit on what the extra funding dollars will be used for at these facilities? The commitment by Exelon, are they ongoing plant improvements? Are they capital expenses? How would you characterize the extra spending?
So Exelon Generation has agreed to provide the support payments or the support agreements for the New York facilities. They perform a backstop function should there be an unexpected outage, and I believe there's also a provision for operation and maintenance needs.
Okay, thank you. You know, we made history earlier this year with our IP settlement, and particularly with the issue of putting a new rapid decommissioning standard in place in New York. And I believe this order just fulfills that promise now to communities in Oswego and Wayne counties. And I believe that our new protocol should be the gold standard for not only New York, because we've taken care of ourselves, but it's a model that I believe should be replicated or could be replicated across the country. I also believe that the NRC and the Department of Energy needs to scrap the current policy of a 60-year decommissioning schedule that is outdated and unfriendly to host communities. And I think I would call on both those agencies and possibly even the Congress to modify the law that would require a more accelerated time frame. Again, I just want to thank everybody, because just remind everybody, New York is now leading the nation on sound policy when it comes to nuclear facilities. And it is also, my guess is moving forward, that these units will remain a critical component of the state's zero emission strategy moving forward. So with that, I'll turn it back to you, Mr. Chairman.
Thank you. Commissioner Velez?
Thank you, Mr. Chairman. I certainly want to join my colleagues who have already spoken in congratulating all of you on the tremendous job that has been accomplished here in so many ways and on so many levels. Just one question, Judge Sipos, following up on Commissioner Howard's comment about the local workforce. And I had the great fortune of having taken a tour of the Fitzpatrick plant a month or two ago, I guess now, and saw firsthand how well that facility is run during that particular period of time. But you indicated in your presentation that the company signed an MOU with IBEW Local 97. So contained in that MOU, would that be where some of the commitments that Commissioner Howard referred to earlier are held in terms of the commitments to that local workforce?
I believe so. That is, it's a recent document. I think it's intended to be a roadmap for going forward. And Exelon, I don't want to put words in their mouth, but my understanding is Exelon Generation and the IBEW Local 97 believe that they have, identified that pathway to go forward. And they will. I assume they will continue to, work on that both from a reliability and labor relations perspective.
Good. That's certainly good to hear, and hope that we would be kept in the loop, as it were, on those activities moving forward. Sometimes I think to really appreciate the job well done in this case, it's often instructive to look at what others say about us and how we operate. And I just want to call attention to everyone, if you haven't seen it, on December 2nd, in a publication called Crane's Chicago Business. This is written by Steve Daniels, entitled "Why Exelon Gave New York a Better Deal Than Illinois." I just refer that to everyone. I'm certainly not going to read it. And there are a number of reasons in his article as to why that's the case. One of them, the fact and the reality that here in New York we have a public service law and a public service commission that gives us an opportunity to play a role where many other states do not play. Many other states, and certainly Exelon, I believe their nuclear facilities are here, New Jersey, Pennsylvania, Maryland, and Illinois. Many of those other states rely on the U.S. Nuclear Regulatory Commission to, in effect, do all of this. And we don't do that here in New York, and I think the ratepayers and the citizens of the state of New York are the ones that benefit from it for a number of reasons. And I'll just highlight again the significance of a 20-year decommissioning plan compared to a 60-year decommissioning plan. And that may be because that's relatively far off into the future, I think, and if I had to predict, I would imagine when we get to that point in time, I'm not sure any of us will be sitting here, but I do have a feeling that those who are sitting here at that time will look back to the December 2021 session of the Public Service Commission, and specifically to this point, and how significant your efforts were in reducing from 60 years to 20 years that decommissioning process. So again, job incredibly well done, and thank you all for your tremendous service.
If I could just make one brief observation about that, right? The federal approach, the federal philosophy is a passive, hands-off, laissez-faire approach. And there are very real economic and opportunity costs that are imposed on communities that are facing a 60-year decommissioning period. And that is really at the that is a deferral or a deference to whatever the operator wishes. So in this instance, Exelon stepped up. This is just me speaking personally, and did the right thing here. And that will benefit the host communities now, and will benefit, future generations. You spoke about, people down the line looking back. It will benefit, those who come after us, the future. And that's really, it's important to get these sites back online for other productive uses or whatever those uses are. It allows those communities to move forward and not just have something that's laying fallow in the middle that's really going to no use at all.
I couldn't agree more. Thank you.
Thank you. Commissioner Bajor?
Thank you. I don't have anything substantive to add, but I would reiterate the sentiments expressed by my colleagues. So thank you very much.
Okay, thank you, everyone. We have sufficient votes, and that said, this item is approved. And
Sorry, I'm sorry, Chair. Could you please call for the votes individually?
Oh, I'm sorry. You're right. Thank you. I skipped a step. So I'm going to call for the votes, starting with Commissioner Byrne.
Yes.
Commissioner Alisi?
Yes.
Commissioner Edwards?
Yes.
Commissioner Howard?
Yes.
Commissioner Valesky?
Yes.
Commissioner Bajor?
Yes.
Okay.
One more second, and your vote?
Oh, I vote in favor. Yes.
Thank you.
Thank you. So we have sufficient votes. This item is approved. We'll move on to the second item for discussion.
Thank you.
Thank you, everyone.
It's me.
Okay, good morning, everyone. So thank you for coming. This is item 401, case 20-W0102, related to the American Water Works Company, New York American Water Company, and Liberty Utilities. This will be presented by Administrative Law Judge Maureen Leary, Tim Canty, Deputy Director of Office of Accounting, Audits, and Finance, Mike Reeder, Deputy Director of the Office of Electric, Gas, and Water, Eric Ryder, Deputy Director, Office of Consumer Services, and Brandon Goodrich, Managing Attorney, are available for questions. Judge Leary, please begin.
Good morning. Unfortunately, my eyeglasses fog, and this is a pretty heavy mask, so I hope you can hear me clearly. I apologize to have to remove my mask. Good morning, Chair Christian, Commissioners Valesky, Commissioner Berman, Commissioner Howard, Commissioner Majori, Commissioners Alessi, and Edwards. My name's Maureen Leary. I am the Administrative Law Judge assigned to this proceeding, which was initiated in February 2020 by a joint petition filed by American Water Works Company, New York American Water Company, and Liberty Utilities Eastern Water Holdings, which I will refer to today as Liberty Eastern. The joint petition sought Commission approval pursuant to Public Service Law 89H of Liberty Eastern's acquisition of 100% of the outstanding capital stock of New York American Water. It also sought Commission approval pursuant to Public Service Law 89F of the issuance of long-term indebtedness by Liberty Utilities Incorporated, as opposed to Liberty Eastern. They are affiliates, to satisfy and replace New York American Water's outstanding long-term intercompany debt. Liberty Utilities will fund the satisfaction of this debt. I will also refer to it as LUCO, as it is designated in the order. Before the Commission today is a draft order adopting the terms of a joint proposal, but also containing additional reporting requirements. In the draft order, the Commission expressly finds that the joint proposal meets the criteria of both Public Service Law Section 89H and 89F and is in the public interest. The order also reflects the Commission's finding that the proposal meets the Commission's settlement guidelines because it is within the range of likely litigated outcomes and may in fact be superior to what that outcome may have been. In addition to the petitioning companies and Department of Public Service trial staff, it's notable that the joint proposal was signed by all parties to the proceeding with the exception of one. The signatories include two public entities, namely the Village of Seacliff and the Massapequa Water District. It also, two additional signatories were local ratepayer groups, activists, namely the North Shore Concerned Citizens and Glenwood Civic Council. A separate ratepayer group known as Long Island Clean Air, Water, and Soils, which I will refer to today as Long Island Cause, CAWS, was not a signatory to the joint proposal and has filed opposition to it. In adopting the terms and conditions of the joint proposal, the order primarily recites the benefits to ratepayers that are associated with the acquisition. Those are well supported in the record. New York American Water's history with the department is somewhat complicated, and the order had to cite some of that history. Context here is important. Both the joint proposal and the order before you have been shaped by several events, including consistent public claims of excessive rates in the service territory and the efforts toward municipalization of parts of the system before and during this proceeding. The order also seeks to meet the objectives outlined in the Commission's 2018 order that initiated an investigation into the inflated real property taxes that New York American Water had used to establish its revenue requirements in the last rate case. Those efforts have resulted in measures that will assure that those errors are not repeated in the next rate case. And then, of course, there was the COVID-19 pandemic and the difficulties associated with negotiating an agreement to authorize this complicated transaction. I cannot speak favorably enough in favor of both the companies as well as DPS trial staff and the other parties in making this happen. And I have to, at this point in my presentation, express many thanks to the Advisory Council, Mr. Canty, Mr. Ryder, Mr. Hogan, Mr. Goodrich, Mr. Reeder, Mr. Rosenthal, Mr. Leacakes, all of whom collaborated to make this happen in a very short time frame. So let me, before turning to the specific provisions of the joint proposal, provide that context I referred to. It's a brief timeline. In January 2018, as I mentioned, the Commission initiated an investigation into the erroneous reporting of New York American Water's real property taxes for the Seacliff District within its service territory. And during the 2016 rate case, the joint proposal adopted by the Commission relied on those numbers. The Commission approved customer refunds thereafter, credits for overpayments, and also ordered the retention of an independent monitor to audit the company and its internal processes involving how it reported, recorded, etc., real property taxes. The independent monitor was in place until September of 2021, and in an October 2021 report made certain recommendations or continued certain recommendations. The companies in February 2020, as I mentioned, filed this joint petition, and less than a month later, on March 7th, the governor declared a state of emergency in our state due to the COVID-19 pandemic. That has had a wide-ranging effect. I don't need to remind this Commission on almost every pending matter. In June 2020, the Secretary issued a notice inviting municipalities and public authorities, specifically in New York American Water's service territory, to submit comments, plans, proposals, etc., that would reflect their plans to acquire any part of the New York American Water system infrastructure. This was really a critical measure that the agency took to, and it actually generated specific valuation and feasibility reports. In response to the Secretary's notice, the Village of Seacliff and the Massapequa Water District both submitted separate valuation and feasibility studies for acquisition of part of the system. These are a part of our record. In October and November, the parties filed testimony, and at that point, the petitioning companies filed a notice of the initiation of settlement negotiations, which continued for approximately 1 year thereafter. In November 2020, Judge Leacakes and I held virtual public statement hearings. I believe there were 6, and there was significant public participation, also a part of this record. Many commenters on Long Island in the service territory expressed opposition to the acquisition, complained about high rates, and supported immediate municipalization of all or parts of the system. In February 2021, additional public forums were held that were specifically focused on the issue of municipalization. So in short, we heard a lot from the public, and it was important that we did that. In March 2021, following the governor's direction to department staff conducted a study examining the feasibility of municipalization and filed a report finding that in the service territory in Nassau County, quote, municipalization is both feasible and under a variety of scenarios in the public interest, even with an upfront investment of nearly $800 million for the purchase of New York American Water's assets, or a pro rata amount for parts of the system. Staff included in its analysis ongoing infrastructure improvements and transaction costs in making that recommendation. The staff made a number of recommendations that actually have come to fruition. Again, this was a study done very quickly and comprehensively, and I really commend staff for that. In October 2021, the independent monitor appointed to address the real property tax errors filed its last report that reflected New York American Water's significant progress in revising its internal processes and controls related to the real property taxes, data recording and reporting, and other measures to address the previous errors. The independent monitor documented certain additional work that remained to be implemented and or tested. This can be seen in the independent monitor's report, which is also a part of the record. In early November 2021, Governor Kathy Hochul signed into law legislation that created 2 new public water authorities for the purpose of acquiring parts of New York American Water's system assets. They are known as the North Shore Water Authority and the South Nassau Water Authority. Immediately thereafter, the joint proposal was filed. After the parties filed statements in support and Long Island Cause filed a statement in opposition, we held a one-day evidentiary hearing on November 16th at which additional testimony and other evidence was admitted. Long Island Cause was given the opportunity to conduct and, in fact, conducted cross-examination. I will review some of the terms of the joint proposal. My intent is not to cover every single one, but to represent for the Commission today the overall holistic benefit to the public as a result of the joint proposal. As I mentioned, it calls for Liberty Eastern's acquisition of 100% of New York American Water's capital stock for $608 million and Liberty Utilities' replacement of New York American Water's long-term intercompany debt that totals $198.6 million. So under the joint proposal, New York American Water will continue to be known by that name. Its operations will continue at the company's Merrick, Long Island headquarters. It will have additional services provided by Liberty Utilities, and it will separately retain its own books and records and be subject to an affiliate code of conduct with its new affiliates. New York American Water's existing employees and management will be retained for at least 2 years, and the existing union contract will be honored. This will assure a smooth transition of New York American Water's operations following the acquisition. In addition, New York American Water will continue to operate under its current rate plan, which was established in the Commission's 2017 rate order, but as that order has since been revised by the Commission in various subsequent orders, including the one that dealt with the tax refunds and those designed to address the COVID-19 financial impacts. The company will also, the joint proposal also calls for the company to operate under a rate freeze until at least April 1, 2023, and in an interesting provision in the joint proposal that would move that date possibly into 2024, the joint proposal requires at least 1 year of Liberty Eastern's ownership to make up the historic test year that it presents to staff in the next rate case. So again, that could move the rate freeze into 2024, another benefit for ratepayers that remains to be seen but is potentially going to happen. The joint proposal also provides for a $23.5 million positive benefit adjustment for ratepayers specifically. It will first be used to write off the make-whole surcharge that resulted from the Commission's various orders. The remaining amounts will be used in a couple of ways to cover deferred levelization surcharges for rate years 3 and 4 in Service Area 1 and to mitigate rates in Service Area 2 in the next rate case. But interestingly, and this is a big plus for those entities seeking to municipalize part of the system, there are parts of this public benefit adjustment that can be used as an offset on the price of the acquisition for a municipality or public entity. There are also additional ratepayer protections, such as acquisition costs of the transaction will not be a part of rates. They will be separately tracked and reported to department staff as a compliance filing. In addition, the costs calculated within this transaction associated with goodwill will also not be passed on to customers in rates. Again, part of a compliance filing in terms of reporting. The surviving entity also has certain protections that are required by the joint proposal. For example, it is required to maintain a BBB rating with the rating services. It is required to maintain a minimum common equity ratio. That is the common equity ratio used by the Commission to set rates. Dividend payments to shareholders are prohibited if that minimum common equity ratio is not maintained. I mentioned the Code of Conduct, and one other financial protection that's significant in terms of its new affiliates is that it limits New York American Water's participation in a money pool to only participate with other regulated entities. It may not participate in a money pool with unregulated entities. Again, financial protections that inure to the benefit of ratepayers. So, customer service, there are several provisions, including the continuation of the negative revenue adjustments. This is a highlight for the joint proposal because of the history of problems with customer service. And as the order reflects, these customer service provisions are designed to really improve the customer's relationship with the surviving entity. There will be also a future low-income program. The order provides for New York American Water in its next rate to work between now and its next rate case to present a program that will identify low-income individuals and hopefully will result in assistance being provided them. This is somewhat new because of a federal law that was passed, I believe just this year, 2021, that provides dollars to the Office of Temporary and Disability Assistance to identify these customers. This department staff is optimistic that this actually could result in a pretty strong low-income program for utilities that is similar to those programs that we see on the electric and gas side. Also, the company has agreed to make good faith efforts to propose financial assistance and arrearage management. As the Commission is aware, during COVID-19, arrearages have been increasing. And finally, in my personal view, one of the strongest parts of the joint proposal are the municipalization provisions that provide the framework for interested municipalities to actually sit down at the table with the company and negotiate in good faith to acquire part of the system. The additional benefit of that is that those negotiations are actually subject to reporting. So department staff will have a level of oversight during that process to make sure that there are good faith negotiations. I want to call your attention to the continuation of existing but the new reporting requirements that also make this joint proposal and the order adopting it robust. They include capital expenditures reporting that will include a 5-year capital investment forecast with system upgrades. New York American Water must annually report to the Commission on the status and completion of its water treatment technologies to address existing contamination in parts of its system. Again, very strong benefit to customers that this happens sooner than later. The order expresses the Commission's expectation that the timeframes provided by the company will be met. That's not to say that there may not be delays. There are provisions that provide for that, but a showing is going to have to be required to agency staff. Customer outreach on simplified annual reports that address the contamination are also required. Finally, New York American Water is required to submit what I'll call enhanced reporting to department staff that would include material facts and circumstances that may operate to impair the provision of safe and reliable service. They also are required to report on cybersecurity risks, emergency preparedness, response capabilities, and anything else that will otherwise affect the financial viability of the surviving entity. I don't think that there'll be questions about the Internal Revenue Code 338 election. As described in the joint proposal, this is not an approval that's before the Commission. The parties are simply acknowledging that this tax benefit is being sought by the companies. What the Commission does say in the order is that the customers are protected as a result of this election in the joint proposal through the offset schedule that's contained in Exhibit 1. So on the issue of indebtedness, it's pretty simple. Liberty Eastern's affiliate, LUCO, will be paying off New York American Water's debt, intercompany debt, and those...
Can we stop for a minute, please, Chair?
It's because I'm going on too long.
Is your mic still on?
It is.
Okay. Well, it went away.
Are we
Is everything back to normal? Or
I think it's good. I've never had that happen here. Okay.
all right.
So the debt issue, it's pretty simple. The terms are better, and that's the bottom line. The interest rate's better. There are a number of other benefits. So a couple of things that are what I will call additional requirements. The independent monitor's recommendations, there was a little bit of a gap, so that the Commission in this order is requiring the continued implementation. Now that the independent monitor's role is finished, it was important to have the company continue the implementation through this transition. We wanted to stress, or the Commission stresses, the expectation that those measures will continue to be implemented. Again, I mentioned the reporting on the status of the updated treatment system, and there is one minor modification procedurally to the order. The order contained a requirement or a contingency that the Commission act, quote, expeditiously if in approving a municipal agreement with New York American Water. There was no question in my mind that the Commission would do that kind of, or to undertake that type of expeditious action, but this is not something that the Commission should be bound to. There are too many potential factors that could go into what expeditious means, etc. So that is the single modification, and yet the order expresses exactly what the Commission normally does, which is expeditiously deal with every matter before it. Long Island caused opposition to the joint proposal. In short, Long Island caused raised valuation, rate issues, other issues not before the Commission in this proceeding. They are more appropriately raised in the next rate case, and the order before you rejects their opposition really to the municipalization provisions. They did not meet their burden in showing that those provisions were not in the public interest. In conclusion, the draft order documents the substantial record in this proceeding and supports the Commission's finding that the joint proposal meets the public interest standard in Public Service Law Sections 89H and 89F. It protects customers, enables municipalization, and mitigates rate impacts through both the rate freeze and the positive benefit adjustment. It also fosters New York American Water's financial stability and assures a smooth transition into new ownership that will enable it to continue to provide safe and reliable service to customers. That concludes my presentation. We are available for your questions. Thank you.
Thank you, Judge Lear. And I want to thank you and your team for doing a great job through difficult circumstances to make these accomplishments a reality. You did a great job of going through the variety of accomplishments achieved through this, but in my mind, most significant are two. In part, the fact that residents of these locations will have cleaner water in the future, and that there's capital plan set aside to make that a reality through the water treatment that you mentioned earlier. And secondly, the various financial protections that are put in place, the rate freeze, the potential for future municipalization, and other aspects create near-term benefits and a potential for future long-term savings as well. So I think this was well conceived, well put together, and I want to thank you for the hard work, you and your team and the others you mentioned earlier, for making this a reality. Okay, and now we'll go to other commissioners for comments. Commissioner Berman?
Thank you so much. Judge, I want to thank you for a very detailed and important summary of what the draft order is before us. I do have a unique perspective in that not only as a former Long Islander who was very familiar with all of the towns mentioned, but I am the only commissioner currently that voted on the 2016 rate case. And so for me, the history of sort of from that to how we got here is one that's really important. There are a lot of lessons to be learned. At the time that we voted on the rate case, there were only 2 commissioners at that time. And we were strongly encouraged for the need to vote on that rate case, because if we did not vote at that time, there was a legal opinion that we would be putting at risk the customers more so by not having some finality and perhaps increasing the rates eventually. So with that, myself and then Commissioner Chair Sayer voted on that rate case. And I actually spoke at the session about the fact that I was very concerned that I did not think that this was something that we should embrace as a good rate case, not because of what was before us from the staff, not because what was before us from the parties, and not because what was before us from the company, but that a clear look at it was really the property tax issue and the huge increases that were outside of the utility itself, that having to undertake that. And so my sense of it was that this was going to be very, very challenging and fraught with issues. And that came really into fruition. There were a lot of different missteps collectively, myself included. And I do think it's important for us to kind of look carefully at some of the lessons that we can be learning as we move forward. After the 2016 rate case was decided, there were also some issues, not just on the high bills, the property tax issues, the challenges between rate in some communities versus others, but also the conservation issues and the less than candid issues related to the ORPS tax issue. We actually, at that time, Commissioner Chair Sayer and myself did not approve as part of the joint proposal when we were approving the order, any of the low-income program proposals that were put forth. And really, primarily, that was because we didn't see at that time that that would be helpful. We saw that as a huge cost shift, and we weren't seeing anything from the parties themselves on customers in the need for that. And we didn't have this, and we have different challenges because we didn't have federal monies from LIHEAP as to water that we could utilize. So we saw that would also be pancaking on further rate increases to other customers, and that was a problem. For me, I feel like a lot then became sort of set up to fail. We did a lot of fits and starts. We were, as a commission, as DPS, we were trying to move forward in addressing a lot of the challenges, working with the company, working with the customers, but there was a lot of outside interference, and that sort of took us in a lot of different challenging ways. And also remember, it was 2 commissioners who voted on a rate case. Other commissioners left, frankly, before, and gladly, they had to decide what would be perceived as a bad rate case. That left a lot of holes to fill, but it also left that anyone then coming in, trying to figure out what happened in the rate case with all these other things. And I think for me, a good lesson is a full commission that's engaged in the issues is very, very important. An ability for staff to have dedicated resources on these issues is really, really important. And also, we need to be, as a body, able to move forward in a way substantively with the resources that we need to do that. And so at times, while well-meaning, whether it's the legislature or the executive, that interference can actually move us backwards rather than forwards. So I share that because I do think that for me, as an insider looking in, it was very unclear the lines of responsibilities. It was very unclear the paths that we were following, and those unique challenges did not help the situation. In fact, the study that was directed by the executive at the time was something that was already being looked at in the pending proceeding, and was going to be something that was going to be addressed on through comments and also analysis. In a sense, that also contributed to a lack, in my opinion, a lack of respect for the commission and the staff to be able to get under the hood substantively and address those issues in the proper forum. And it left customers as well as the utility confused on which pathway to go, because it many times felt like a whack-a-mole. No matter what you did, things kept coming back up, and you weren't able to figure out the right pathway to clearly identify and address the issues. I think that, in my opinion, is something that I've spoken about before, but for me, I share it now because we do need to take account of our responsibility to ensure that we are focused on the proper regulatory oversight and role, and how to make sure that we are setting forth the right regulatory framework for our decisions, rather than at times feeling like we're in crisis mode and reacting to it and trying to figure out new pathways that aren't necessarily helping us stay on track and moving forward. Here, for me, it also gets back to my sense of making sure that we do more collaborative discussions, both internally and externally, and make sure we're focused on those pathways. As I go forward and I look at this, I do think that this is something that I could vote for. I will be concurring. I want to recognize, though, that in here, we are setting up a couple of things for the next steps and the next phase. It does not mean that we have implemented a full low-income water program. What it means is that we have a framework to be looked at in the next rate case. And so it's our obligation as a commission, working with DPS and others, to make sure that we get it right. This needs to make sure that we are maximizing the resources available from the Low-Income Household Water Assistance Program. That will be a clunky process in that we will need to rely on the federal agencies involved, as well as OTDA, to do this. So for me, when I look at this, I want to make sure that we do it and we make sure New York gets as much as we can out of this program and address any challenges at the get-go so that customers are not negatively impacted by that. And so it's for us to be very careful. When we do look at the next rate case that will involve that, we need to also not do a cookie-cutter approach, which means that we need to understand the utility customers in that area. We need to understand the impact on both public and private, and we need to make sure that we are carefully managing that and understanding that. We can actually look to some of the challenges we saw in other utility, the Suez case, where we had, at that time, had a low-income program framework, and they were supposed to come back, and there were some challenges with that. Some of those challenges are not necessarily the same that it might be in United Water, but that gets to the second prong. The issues with the 2016 rate case, as it related to the conservation block, where we took a cookie-cutter approach, we moved what was successful in the Suez case, in my opinion, to the American Water case without a full understanding of what that would mean, without actually fully publicly discussing it in a way that would be fully understood by folks. And so when then it came to be, we should have actually tested it in a way that would have helped us, rather than having to figure out how to avoid the issues and have a bunch of different emergency motions and other things come before us to fix those challenging issues. The other thing is, by having a big rate increase that was delayed due to COVID, when we finally had that increase, it was nearly a 26% rate increase in May of 2021. For me, that then was a rallying cry to the legislature to, in June, adopt a legislation directing the municipality, the water authorities. And so for me, I do believe that we as a commission should have looked at some of this and addressed it and gotten ahead of it, rather than having the legislation now be something that sort of dictated a lot of the next steps. In any event, I look to the fact that in this case, in this matter, There are going to be a couple of next steps, some of the rate cases, the low-income programs, and others, looking at some of those financial impacts, the independent monitor, et cetera. But there also will be 3 potential transactions that will come back to the Commission. The North Shore Authority, Water Authority, part of that may come here. The Massapequa Municipalization, as well as potentially the Hempstead Municipalization. Now, for me, I recognize that the Hempstead one is one where the town of Hempstead was very much concerned about that, what that mean. In fact, frankly, 90% of the customers or thereabout fall into that category. So we need to be very careful from our own management of the next steps. Municipalization of a water utility is not necessarily the saving grace, and may also actually just be, as for some may say it's fair, some may say it's unfair, a cost shift to the other customers. And so we need to make sure that it's not an inappropriate apples to apples comparison to say, you see, American Water's American Water's bills are so much less now, and we're not dealing with that over on the other side. And we also need to be very careful that as staff is negotiating and working with folks in the next steps as it relates to municipalization, that we take an approach that is not an advocacy approach, that is not trying to browbeat one particular group or another into what is the right way. This is now a much more hands-off approach. It's a local issue approach, and it's one that really needs us to help in a way that is collaborative, but not is trying to push a particular way or not. From my own perspective, municipalization can have some pros and can have some cons. We're in a transition period right now. The DPS study, as I read it, is not making an assumption that municipalization can be as efficient as a private water utility. And so there is no assumption on which may be more efficient or not. But when we do the analysis, we need to be really, really careful that we are giving a factually based analysis that is not trying to push in one direction or another, and looking at that. So with that, I'm going to wrap up in just saying that I want to thank all staff who've worked on all of these issues from when the 2016 rate case was first filed, through all of the different challenges. Nothing that I say here is in any way saying anything negative about staff. In fact, I have in highest regard each and every staff who have really lived and breathed all of the challenges thrown at them and dealt with it in a way that I think led us to a better product, a better way of collaborating, and trying to move us in a path forward. And so I raise these things really so that we have some sort of insight and perspective on where we are. I do want to just point out one minor thing. The change in the joint proposal that takes out from the joint proposal of directing the PSC to act expeditiously, that I think is appropriate, but I think it's also something that we need to generically also keep in mind as we go into settlement discussions. Joint proposals, when they're directing the PSC to do something, is something that we need to be very mindful of, because that's a delegation of authority that we need to really carefully weigh in as a commission body. It's for us to weigh in, to get comments on what it should be, and it's also a delegation for the chair to work through on what some of the proper timelines are on things. So I just raised that because that's a good takeaway, not just within this joint proposal, but just across the board. So thank you so much.
If I could just address one, because I don't want the commission and this is a long document with lots of footnotes. I want to refer the Commission to, in fact, one of those footnotes which recognizes or expresses the Commission's recognition of this sort of two sides to municipalization in terms of the impact on the tax base of a municipality. So I think the order very fairly presents that we are not taking some advocacy position here. I wanted to reassure the Commission, and that may have been lost in translation. And I actually, I think that that is a better signal to send than rah, rah, go municipalization. It's a much, more sort of middle of the road and fair approach. It is up to the local municipalities and water authorities.
Absolutely, Judge, and that's actually one of the reasons that I can vote in concurrence with this, so thank you.
Thanks.
All right, thank you. Commissioner Elise?
Thank you, Mr. Chairman. This will assure our customers of a safe and reliable service, and to that end, it is clearly in the public interest. It is within the Commission settlement guidelines, consistent with the goals of the CLCPA, and it provides improved and expanded focus on customer service and low-income customers as well, and I'll be supporting it.
Thank you. Commissioner Edwards?
Yes, thank you, Chair. I will say that I agree with much of what Commissioner Berman has said, so I'm not going to repeat it. This was one of the major things that when Commissioner Howard and I joined the Public Service Commission, and I, at that time, truly could not believe the service quality and the rates that the customer had to endure. This is definitely not a 100% fix, because what we don't want is for these same issues to creep up, but now it's with another company, or now it's with municipalization, which is complicated. I want to thank the staff for working so hard on this. I also want to thank the Nadels, who were actually customers who took the time to walk through all of the complicated issues that were around this. The Nadels and other neighbors and customers that were passionately talking about their experience. So I agree that this is not 100% fixed. It's definitely progress, and I will be supporting it. Thank you.
Thank you. Commissioner Howard?
Thank you. First of all, in the world of staff doesn't deserve enough credit for doing the unpleasant for years and years and years in a row. This is a perfect example of a case that you guys really persevere through difficult and often very contentious times, not only with us in the Commission, but those other affected parties. I have a couple of questions first. Of the three major water districts of New York American Water, can someone tell me how much the tax burden is by each of the three, the North Shore, Massapequa, and Hempstead properties?
Yeah, for Hempstead Hempstead and Massapequa, it's roughly about a third of the bill is property taxes, and up in Seacliff it's about 50%.
Great, thank you. And one other question. Are we aware of any other potential tax cases out there, long-standing, that may in fact accrue to the benefit of ratepayers going forward?
Yeah, the company has a number of tax challenges, and there's one in particular related to when the four-class system was implemented in Nassau County, and initially the way the law was written, it only applied to the county, but when they effectuated it, they applied it to all the villages and school districts. And the company has won on that in court, and it's being appealed and negotiated right now.
Do you have any idea what the magnitude of that outcome could be for New York American Water?
I don't want to impact any settlement negotiations, because a lot of this is interest from the date that it happened, which was, I think, early 2000, but it's significant.
Okay, enough to provide potential real rate relief to customers going forward?
Yes.
Okay. Now, the rest of these are somewhat comments, Mr. Chairman. Well, first of all, it's unfathomable to me and how local elected officials could implement a system where more than half of a customer's bill goes to taxes. It is just unbelievable, to the point of incredible. And this is an issue that didn't just sneak up on anybody. Any examination of Nassau County's four-tier property tax system would see that as clearly unfair, regressive, and I would dare say use the phrase usury. The last year in Nassau County has seen a clarion call by property tax owners on the need to fix Nassau County's real property tax system. Any reform to that system must include, in my opinion, reforms to the taxes placed on utilities by Nassau County. And as New York State is poised to invest billions in upgrades to our electrical grid, it should not become an opportunity for a windfall for local governments. Under the current system, and particularly in Nassau County, and I would dare say New York City, these billions of dollars new investments will result in hundreds of millions of dollars of new taxes going to municipalities. And I believe that all climate-related infrastructure spending that will be costly enough on its own, that any additional cost to due to local taxes will require ratepayers to pay twice is just unacceptable. And as far as municipalization goes, Nassau County's localities have had more than a century to municipalize its private water systems. And many decades ago, New York City purchased assets of the same company that now are part of the broader New York City system that were previously private. It is my belief that with over $40 million at stake in local property tax revenue, I do not believe that the largest municipality in this system, in this case the town of Hempstead, will go and ever municipalize due to the fact of the fiscal hit that the town may actually take. It is very unfortunate in this state that policymakers often hide the impact on customers through these, I would dare say, phantom taxes, local taxes, on utilities because of the somehow broad and mistaken belief that it's the companies that pay these taxes. Customers pay these taxes. It is not the utilities that do. So a fair, transparent, progressive taxation is needed. And quite honestly, it is my hope, and we do, that the Congress revives the SALT deduction for municipal taxes, that in fact it would be far better for Nassau County ratepayers and taxpayers that these large tax increases be shifted to taxes that are in fact deductible on my federal income tax, whereas the embedded tax is on utilities is not. Again, I would just implore that the incoming administration in Nassau County at the executive level and as the reconstituted legislature take this issue head on. It is not going away, and as I give the cautionary tale, particularly as we build out infrastructure in Long Island that will be needed to integrate our offshore wind assets, that could again be a major and unnecessary windfall to local governments. But again, I do congratulate you, Judge, and the staff here on coming to a pretty good solution given a bunch of bad potential outcomes. And as Commissioner Berman said, there may be many years of sin that we are trying to overcome here. And again, congratulations, and I will be supporting this measure, Mr. Chairman.
Thank you. Commissioner Vest?
I have no comments or questions other than to certainly salute the diligence and perseverance of DPS staff who have navigated the shifting sands over the years underneath this issue and getting to the joint proposal and getting that proposal to the order that is before us today. Thank you.
Thank you. Commissioner Major?
Thank you. I am going to vote in favor of this item. I thank staff and everyone who worked on it. Importantly, it will result in some relief for ratepayers, at least in the short term. Investor-owned utility water systems are anomalous in New York State. According to the staff report that's been referenced on the feasibility of municipalizing New York American Water, issued by DPS staff earlier this year, 96% of New Yorkers have municipal water services and therefore do not pay any property taxes through their water bills. But privately owned water companies must pay local property taxes, and those taxes are recovered in utility rates. The unusually high property tax burden that's been referenced already today that has fueled American Water's high rates will not be erased by the takeover of Liberty. I do think that the staff report makes a strong case for municipalization, and an important part of the settlement we are approving today requires Liberty to work in good faith with local authorities to municipalize parts of the system. The greatest benefit of municipalizing American Water would be that a public entity is not subject to property taxes. Local government entities collect $43 million in property taxes from American Water, which are passed on to ratepayers. The ratepayers don't see these property taxes as property taxes, but rather as water rates. Since property taxes are considered the type of prudently incurred costs that utilities are legally entitled to recover, this body cannot lower water rates covering those expenses. That said, you can squeeze a tube of toothpaste on one end and cause it to bulge on the other, but that doesn't lessen the amount of toothpaste in the tube. There's a bit of a shell game going on here. Reducing water rates by removing property taxes from the utility without structural reform does not reduce expenses for the local governments that rely on the property tax revenue. The DPS study, as well as others referenced in that study, suggest that real savings, reduced expenses, can be achieved through municipalization. Perhaps more importantly, the local government's revenue collection can be both more transparent and more equitably distributed. To quote from the study, collecting property taxes through water rates is regressive, inefficient, and not transparent to customers, end quote. American Water customers are subsidizing local government services for their neighbors who are serviced by other entities in a way that is not reciprocal. This is not to say that most residents of Nassau County aren't familiar with high property taxes. It's well established that Nassau County has one of the highest median property tax bills in the nation. This is not new. There are many reasons for this, and this is not the forum to analyze all of them. However, multiple local government entities, often with overlapping jurisdictions and duplicative responsibilities, contribute to the high property tax burden in New York State. In Nassau County, many special districts, some of which might elsewhere be reasonably characterized simply as administrative units of other governmental entities rather than local governments in themselves, in Nassau County have independently elected boards and/or taxing authority. Multiple and overlapping local governments can obscure the true cost of overall government service or how those services are paid for. Property tax assessed against a water utility, in this case, provides a great example.
To the extent water rates are being charged to cover property taxes, the rates are essentially not going towards water, but other government services, not necessarily just being provided to the ratepayers. According to the DPS municipalization study, again I'm quoting, for the Sea Cliff service territory, taxes make up more costs than the combined costs of actually running the company and delivering water, end quote. Paradoxically, attempts to slice and dice rates add to the confusion. In this case, property taxes account for half the bill in some parts of the American Water Service area, as has been mentioned earlier, and about a third in the other parts. Utilities overall are assessed different property tax rates than other entities, again, as has been mentioned earlier. In fact, Nassau County is the only county outside of New York City that has a 4-class property tax system. And one of those classes charges higher rates to utilities. Multiple layers of government and quasi-governmental entities is common across New York State, but Nassau County is a special case. As of a few years ago, although only 2% of special districts across New York State are independent, which is to say they have their own elected boards and are not simply administered by towns, a majority of them statewide are located in Nassau County. 31% of all revenue collected from special districts in New York State are collected from Nassau County special districts. More than half town revenues collected in Nassau County come from special districts. Special districts in Nassau County were responsible for 65% of all real property taxes and assessment revenues collected by towns. Bills for services provided specifically in Hempstead were reportedly up to 3 times higher than those provided in other districts, in part due to the number of special districts rather than the level of services provided. In terms of water districts, according to the DPS municipalization study, the town of Hempstead alone operates 6 water districts within its borders. According to the DPS study, for those governmental entities not 100% in American Water's service territory, tax revenue lost from municipalization would have to be collected from the entire tax base, not just from American Water customers. I think that makes sense, again, because the property taxes collected via water rates are paying for services enjoyed by the entire tax base. So what type of local governments are being subsidized by property taxes assessed to American Water? Well, according to the DPS study, they include the county, 2 towns, 34 school districts, and 18 villages. To quote from the study again, quote, on a per customer basis, American Water customers pay approximately $141 per year more to the town of Hempstead than their neighbors with municipal water, end quote. There are a finite number of quality public administrators, and the more they are spread out among governmental entities, the less overall impact they have on the overall quality of governmental services. The DPS municipalization report notes that the 30-plus water systems in Nassau County each have, quote, separate billing systems, call centers, management and supervision, design and construction teams, operations and maintenance personnel, and office and administrative support employees, end quote. Moreover, there's an inverse relationship between the number of local government units and the amount of press scrutiny devoted to any one of them. The bottom line is that American Water ratepayers are not just paying for their own water, they are subsidizing all manners of government services for their neighbors who get water from public entities. Today's actions address few or none of these things. Again, while I do believe that the Liberty takeover will result in some savings for ratepayers, there are larger structural issues that are beyond the scope of this action or the PSC. Fundamentally, the tax rates by class are set locally, and the decision about whether to municipalize is also largely a local decision. The order requires Liberty to engage with the local taxing jurisdictions and authorities on municipalization, which, as I noted, is one of the positive elements, in my opinion, of the settlement before us. In parallel, I would strongly encourage Liberty to also engage with local jurisdictions on ways to bring more sensibility to the property tax situations affecting customers. So thank you very much.
Thank you. And so we'll go to a vote. Okay. My vote is in favor. Commissioner?
I concur.
Commissioner Alisi?
Vote yes.
Commissioner Edwards?
I vote yes.
Commissioner Howard?
Yes.
Commissioner Valesky?
Yes.
Commissioner Majori?
Yes.
Okay, this item is approved and recommendations are adopted. Thank you again for your hard work on this. Okay. That said, we're now moved to the consent agenda. Do any commissioners wish to comment or recuse from voting on any of the items on the consent agenda? I'll begin with Commissioner Berman.
Thank you. I have 5 items that I want to comment on. The first is item 164. This is a petition for rehearing by the Ithaca Tompkins International Airport to have its geothermal project funded. The Commission had denied this in its June 21st, 2021 order in this proceeding. If this was just a straight free rider issue, I would be voting in favor of it. I believe this is a larger issue that gets to the heart of what we are doing in Tompkins County, what we're doing in our clean energy space, and I have raised in numerous sessions my concern, in particular at the last session, as well on some other items related to Lansing and Tompkins. I really think it's important for us to really have a further discussion on what's happening. This is in the heart of where there's a gas moratorium. And as I look towards it, some of the challenges that I have is that there have been a number of both federal and state agencies involved in the expansion program at the Ithaca Airport. In fact, the Ithaca Airport was very much engaged with numerous state agencies on doing this, not seeking it through gas, going through geothermal, and working with what they had where they needed gas, but to try to cut down some of that demand. In fact, this came about initially in the 2018 RFP that was submitted in the first NYSEG RFP. Because I have raised these concerns before, because I feel that we need to get a closer look and a handle on it, and because I do feel that when we are looking at economic development issues, whether it's through Empire State Development, NYSERDA, regional economic development councils, many times the DPS and PSC are not necessarily there in the utility on the front end. And what happens then is that people move forward on projects looking at the potential funding streams that may be there without necessarily knowing that they have to go through a process and the commission may have to adopt it. In this case, it was also a little clunky because we picked winners or losers in the NYSEG non-pipes alternative demand alternatives. And for me, it leaves me still with many questions about the path forward. And if the airport is one that has been working with all of these entities, the absence and silence from the other state agencies on this here leaves me with further questions on what may have happened and how we could have gotten on the other side of this in a better way. So for that, I'm going to be voting no on 164. However, I do want to underscore, if it's about a free ridership issue in and of itself, that is something that I would not be in favor of. I don't think here that we can just use the free ridership issue, though, as to, well, it got completed 8 days after the second RFP because of all of the other underlying issues that were going on. So I just want to make it clear. Item 367. This is a petition to a draft order to approve NYSERDA's administrative funding request for the 2022 CES compliance year. I'm a no. For me, I recognize that this petition is an annual petition that has to come before us. I recognize that NYSERDA did that, and I recognize that we now have an obligation to look at what we should be doing in terms of their approval of funding. However, for me, as I look at this, one of the issues in the order is it says that it's reasonable that the NYSERDA team must grow as the workload of the CES continues to grow. And NYSERDA itself recognizes that there's been a lot that's been done and pancaked on since the CLCPA. And in light of the growing role in increased expansion of their renewable energy targets pursuant to the CLCPA, they feel that NYSERDA feels that it's going to need more staff towards those activities, and therefore they're seeking a lot more funding. I believe very strongly that we should look at the proper resources, staff resources across the board. I'm tired of it just being NYSERDA who we're looking at. We need to have a further discussion. We need to look as a state at what we're doing when legislation gets passed that has significant cost drivers, not just with the staff that may need to be done, but overall what happens with that. I'm left with blanks, and I think that in this case, the fact that NYSERDA is seeking additional funding directly related to clean energy legislation that was recently passed, they have an opportunity to ask for that in the budget where there can be a more robust discussion on exactly what is needed. I'd also like to see very clear lines on how much of the resources go to different activities, Climate Action Council being one of them. And I'd also like to see us having more engagement on those issues substantively so that our staff can have the resources, our staff and our commission, to the extent that it's going to impact what we're doing, we need to have that information. I don't doubt that they need more bodies, but I don't doubt that we need to have a better way of handling this in a way that helps all of us in that. So I'm a no. Item 377. This is the petition for rehearing by New York City and the Northeast Clean Heat and Power Initiative on our standby exemption continuation order. This order that they're seeking rehearing on is from the May 14th, 2021 standby exemption continuation order. Ironically, at the May session in 2021, it was also item 377, for what that's worth. And I concurred in part and dissented in part. And I do believe that the city and Northeast Clean Heat and Power Initiatives rationale for why they're seeking petition for rehearing are absolutely on point, and I fully support that they should be granted rehearing, and we should be looking at that. I do want to refresh people's memory because I do believe strongly that this is one petition for rehearing that should have been, that should be granted. The underlying order was addressing the continuation or not of standby rate exemptions, and the order in May supported essentially three tracks for the existing standby rate exemptions. One, the Commission was going to continue exemptions relating to Public Service Law 66-J and 66-L indefinitely. Two, the Commission was continuing exemptions related to renewable energy and energy storage technologies for another 2 years. And three, the Commission should not, and I underscore that because it's part of my concern then as well as today why I'm voting no, should not renew the exemptions related to combined heat and power, CHP. My concern still is, and it's an agreement with New York City and Northeast Clean Heat and Power, that I feel very strongly that the failure to extend the CHP exemption like the other exemptions that are getting extended while we await resolution on the standby rate policy matters in other proceedings really makes no sense to me. We would grant this exemption again for other exemptions. We're extending it while we work that out, but yet we don't extend it for CHP. I feel it's some misguided reliance on the fact that we can't do that under state energy policy, and saying that since the CLCPA law doesn't allow it, we're not going to grant the exemption extension for CHP. That doesn't make any sense to me. We're still working through that. We did it for the others. I don't see why we wouldn't do it, except that we're picking winners or losers and chilling, frankly, ongoing projects. I feel there's a great opportunity for us to make sure we're consistent with not the May order, but the ones before it, in particular the 2019 Commission order that granted the exemption extension for all existing exemptions, and at that time said we'd look at this in an ongoing collaborative in the standby rate proceedings. Traditionally, when we have commission precedent, if we're going to change our rationale and what we're doing, we need to really carefully and with proper discretion lay out the reasons for that based on the record on what makes sense to do. The order that's now a petition for before us on a petition for rehearing had nothing in the record, in my opinion, that would support our changing that commission precedent. I don't think it's helpful or prudent to just cite to some oversimplification and erroneous reliability on the state energy policy and CLCPA generically as a reason to change the commission precedent. The underlying order to me was fundamentally flawed. I do believe we're actually discriminating against the CHP exemption extension by denying it versus the others. If we did grant this extension for the limited duration to the others while we're doing that in the standby rate proceedings, I don't understand why we wouldn't be totally consistent in our actions and extend that same one for the CHP. Most importantly, it would allow us to address this issue more thoughtfully and perhaps with collaboration in the proceedings. So for me, as I look forward on this, I do think that we may actually, by not approving the petition for a hearing and granting that exemption, not granting the exemption to CHP, it may actually take us backwards if we eliminate this exemption inappropriately without carefully looking at it more holistically. So I'm going to be voting no. On item 461, which is this Suez water approval, I'm going to be concurring with reservations. I am going to raise two issues. The multiple interveners raised a concern and raised some concerns on what we were doing, and the draft order basically says those are things to be discussed in a future rate case. I feel for my own self that some of their concerns are things that we should be tackling a little bit more in depth now and not just punting on those to a future rate case, even if it's to flush out some of the issues that may be there and what we may want to see in the rate case. And I do just want to clarify that here this also has a low-income assistance program, and that the order does not specifically say it, though I want to make clear my expectation is that whatever is done collaborating with parties on the low-income assistance program must come back to the Commission. That is also the same for a feasibility study on municipalization that is going to be being looked at. That must come back to the full Commission body, not just filing it in in DMM, but for us to actually look at and see what it is. It's really important on both of those issues that the commission looks at carefully how to do that. 561. So 561 is one of these weird items that most people would say, what's the big deal that, you're even talking about it. This is like one of these things that's really important to me. I'm going to be voting no on this item. To me, the issue here is I believe that the order itself is completely unnecessary. And I don't see the value in us having an order that is essentially codifying what is being done in a way that could actually, when we're all no longer here in December 20 years, if this comes up where someone is asking for an assignment of an ALJ, they may cite to this order as precedent for the commission deciding which ALJ should be assigned. So I want to make it very clear. There isn't already assigned an ALJ. That was done under the delegation of authority to the chief ALJ to decide who should handle a case, and that was done. The commission does not need to assign a specific ALJ or any ALJ to this case. The reason the motion came about, the emergency motion, for us to say, yes, please assign an ALJ, and also tell the ALJ that he or she must set up a procedural schedule, is because during a procedural conference with the parties, there was at that time not a petition filed on universal service funds. And at that time, the ALJ who was assigned, ALJ Sayer, made a comment, appropriately so, that he was not sure if he had authority or not to set forth a procedural schedule without that petition. That caused some parties to be concerned. I think ALJ Sayer was absolutely right to raise the question of whether or not he had the authority. And then came this emergency motion seeking us to act. In the meantime, since that motion, the petition that would give him the clear jurisdiction to set forth the procedural schedule as he would do came through December 15th. Now, I would say the parties who moved for that petition, who submitted that petition, should have also weighed in on the no longer clear need for this emergency motion, because we already have an ALJ assigned, and we have the petition that was what was being waited for to move on the procedural hearing. I am very passionate on the fact that I don't believe that this order is necessary, and I also don't want any misinterpretation that we are handpicking a specific ALJ. At this time or at any other time, we have to carefully weigh what that is. The order makes clear that there already is an ALJ assigned, and that we expect that he, in his due diligence, will set up a procedural schedule as he sees fit. So there's no harm in the order, except to the extent that we shouldn't be taking up unnecessary orders, we shouldn't be wasting the commission or staff's time, and we should leave it to ALJ Sayer, who's already been assigned, to set up a procedural schedule. And if there are still ongoing issues, to make a ruling, and if there are still ongoing issues, the normal processes of appealing that ruling that may at some point come to the commission can come. But I have no doubt that this was something that could have been handled without the expenditure of time and effort on our part. So for that, I'm going to be voting no. Thank you.
All right, thank you. Commissioner Alisi?
Nothing to say, thank you.
Thank you. Commissioner Edwards?
I'll be voting yes on the consent agenda.
Thank you. Commissioner Howard?
Yeah, I have comments on 3 different items. First, on item 164, the petition from the Tompkins County Airport. I just want to go on record and note that the Tompkins County Airport has received tens of millions of public dollars from the state, federal, and local governments, and I agree there is no need for additional funds from ratepayers to underwrite the capital needs of this airport. Second, on item 367, I feel it necessary to remind New Yorkers that these funds, all funds virtually administered by NYRSA, come directly from ratepayers and customers' bills. As the vast majority of NYSERDA funds do. And the Commission, in that regard, acts as the sole fiduciary on these levies. And that's contrasted on how the Department of Public Service is actually funded through the state budget. Even though our operations are also paid by utility customers through 18A assessments. So going forward, there are two things that I would hope. I concur with Commissioner Berman's comments that those issues regarding CLCPA compliance and administration, those being in fact a legislative mandate, I believe that the legislature has an absolute duty and responsibility to appropriate said funds to implement those programs, as opposed to us, who put in the levies to provide the cash to make those funds go. I believe the legislative process is far more transparent and ongoing, subject to greater debate, and I would hope that that would be a watchword as the next budget is adopted, and certainly going forward as we expect to see billions, possibly hundreds of billions of dollars of new expenses necessary and investments necessary to meet our climate goals. And finally, on item 461, many of the issues confronting the Suez system are actually in parallel to those brought up at New York American Water. And I just want to say there is nothing in this order that precludes any municipality to take over part or all of any one of the Suez systems. That, again, this transfer of ownership on the high level, if local governments feel the need to pursue these things, they are certainly within their ability to do it, and there is nothing in this order that would preclude that. So those are my comments, Mr. Chairman.
Thank you. Commissioner Valesky?
I have no comments on any of the items.
All right, thank you. Commissioner Major?
Thank you. Two brief comments. One is on item 164, Tompkins County Airport. I'm going to vote in affirmative on this item. I do want to note, as Commissioner Howard had indicated, that the Ithaca Airport project is a significant economic development project in Tompkins County, and that the state has made considerable investments in the same. I wanted to make sure that denying funding for the associated geothermal project would not throw a wrench in the larger airport project, and I am satisfied that it will not, as the geothermal project is complete and the rationale for this order makes sense to me. Second item is 463 Bristol Water. While I will vote in the affirmative on this item, I wanted to acknowledge that many of the public comments reflect a real sense of frustration with this rate hike. I commend staff for taking the public comments seriously, running them down, and addressing them in this order. Further, I'd like to commend staff for their work and review on this case. I note that the company's original request was for a 104.1% increase. We are not approving that request, but instead are approving a revenue increase of 57.2%, which is reflected in this order. Unfortunately, I think the case for the rate hike is pretty compelling and justified. So I'm going to vote yes, but I have an empathy for those expressing frustration. Thank you.
Thank you. So we'll take a call for the vote. My vote is in favor of the consent agenda. Commissioner Berman, your vote?
Thank you. I vote yes, except 164, 367, 377, and 561. I vote no, and 461, I concur. Thank you.
Thank you. Commissioner Elisa?
I vote yes.
Thank you. Commissioner Edwards?
I vote yes.
Thank you. Commissioner Howard?
I also vote yes.
Great. And Commissioner Valesky?
I vote yes.
Commissioner Majora?
I vote yes.
Excellent. Thank you. The items are approved and the recommendations are adopted. Secretary Phillips, is there anything further to come before us today?
There's nothing further.
Thank you very much. And with that, I adjourn. Thank you, everyone, for your time, and happy holidays.